and Oliver Dunford. I must say that I am not watching the tournament at all, but I think it has been dwarfed in popularity in the Thompson household by the World Baseball Classic, which I thought was awesome.
That was great.
Yeah. I found myself sort of kind of rooting for Venezuela there at the end.
Oh,
Is that not patriotic enough? They
no.
had two brewers, and the American team only had one brewer. But it's
That was
very
great.
cool to see. Baseball, I think, is having a moment right now.
Definitely. It's good to see.
Yeah. Meanwhile, the tournament I could care less about. Maybe that's because Wisconsin stinks. But anyway, to the Supreme Court. We have a show today that's going to start with some new grants that the court will be hearing in the coming, not this term, but the following term. Actually, I think one of them might actually be this term. But Damien will fill us in on that. I'll talk about two opinions that came down in the past couple weeks, and Oliver is going to preview some of the upcoming cases that are happening in the next couple weeks. Some more exciting cases to be heard this term. And I'll end it with quizzing these guys on a little Supreme Court trivia. But first, Damien, that leads us off to you. The court, I think, has granted a couple cases since we last talked here on the show. What are those cases about?
Well, the one I believe that you referenced that's going to be argued next term is an environmental case. The title of which escapes me, but it's United States Air Force versus an environmental group. And I apologize for not knowing the case title. Maybe one of our production assistants can get that for us while we're talking. But it's an environmental case that also has a more basic judicial review aspect to it. As I understand it, the U.S. Air Force has used a portion of its base in Guam for many years for the purpose of destroying old munitions. And naturally, this is a process that involves the disposal of hazardous waste. And so the Air Force is subject to a federal environmental law passed in the 70s that deals specifically with the disposal of hazardous waste, the Resource Conservation and Recovery Act, commonly referred to as RCRA. As I understand it, since the early 80s, the Air Force has been applying for and obtaining permits from the relevant Guam Environmental Agency to continue doing this munitions disposal work. And that a few years ago, an environmental group challenged the renewal of the permit, and as I understand it, the Air Force argued that, well, we are still operating under our former permit, and we have just applied to Guam for a renewal permit. Until that application is decided, we're still allowed to operate legally under our old permit, and you can't challenge our application for a new permit because that's not final agency action under the Administrative Procedure Act. And the District Court in the Ninth Circuit held that no, under the circumstances of this particular statutory regime, the application for a permit is itself a final agency action. I think principally because by applying for a new permit, it does allow the old permit that otherwise would have expired to continue in effect. So I think that was kind of the linchpin of the finality analysis. On the merits, it's a NEPA challenge. The argument is that the Air Force didn't do sufficient environmental analysis of the impacts of its proposed hazardous waste munitions disposal. And the Ninth Circuit and the District Court agreed that they should have done a NEPA analysis. The government's position is that NEPA doesn't apply at all, that RCRA has its own environmental analysis requirements, and those effectively displace the general NEPA requirements. It's an interesting issue because, just last term, the Supreme Court issued perhaps its most significant NEPA case ever, the 7-county infrastructure case,
Right.
where the court basically said NEPA has been misinterpreted for years by the lower courts, that it's not nearly as broad as people thought, that agencies should get a lot of deference when they make NEPA decisions, and that, you know, a NEPA victory should be the rarity, not the norm. So it's interesting that the court has decided to again take up a NEPA issue so quickly after that ruling. But the finality issue is also, I think, an important one, because what qualifies as final agency action is something that has significance well beyond just RCRA. It's a common requirement for all sorts of administrative.
Well, and it's something that you
Oliver
yourself,
himself knows about when it comes to fireworks.
Yeah.
well, what you, I mean, you yourself litigated a final agency action case
That
before the
is correct.
Supreme Court.
Yes. Yes.
I have, so the case is Department of the Air Force versus Guhan, or Guahan.
Yeah, that's the
And,
local environmental group.
Yeah, it's exactly, it's like a local Guamian or Chamorro environmental agency. Two quick questions for you. So when I saw this grant, I assumed, and maybe I'm incorrect to assume, that this is sort of a isolated Guam-related issue, and that it wouldn't really have significant long-term precedential effect. But as you explain the case, it seems like it does have, it raises at least two issues that have significant impact on future federal court litigation.
Potentially. I mean, I'm not sure. I'm not sure how common this provision is in federal law, that by applying for a renewal permit, you automatically extend the underlying permit. Now, a lot of the stuff that we do here at PLF concerning federal permitting, it's usually sort of one-time permitting. You know, you want a permit to fill in wetlands, or you want a permit to build a house, and you might accidentally take a Delta smelt in the process or something. So there typically wouldn't be the need to have repeat permits. Now, that sometimes does happen of things like stormwater permits or what have you, and I'm not quite sure what the rule is, but I think, yeah, there is the potential for an impact from this case well beyond just the obscurities of hazardous waste disposal.
Are both issues petitioned and both issues granted?
That's my understanding. Yeah, the court just granted the Solicitor General's petition, and that both questions were raised.
Any questions, Oliver?
Nope.
Second case, Damien.
Now, the second set of cases, these are immigration cases concerning the administration's, the Secretary of Homeland Security's decision to terminate temporary protected status designation for Haiti, and I believe for Syria, if I'm not mistaken. Certainly, Haiti is one of them. This is something that I know absolutely nothing about, so I'm going to make sure that our listeners won't, all 12 of them, won't excoriate me if I get this grossly wrong. But as I understand it, the relevant immigration statute says there shall be no judicial review of decisions to either designate or terminate TPS determinations. And here, that appears to be exactly what the plaintiffs are doing, that they're challenging the decision of the Secretary to say, in Haiti's case, that it's no longer qualifies as a temporary protected status, which means that persons here who otherwise could be deported to Haiti can now be deported. When TPS status is in place, deportation can't happen. So that's why they are challenging. As I understand, the lower courts got around this statutory bar in judicial review by saying, well, the statute just prohibits challenges to sort of the substantive decision whether TPS status should be eliminated, whereas their challenges, we're more about challenging the process whereby the Secretary came to this conclusion. Like, did she just sort of engage in perfunctory consultation with other agencies, or was she acting out of with a preordained conclusion in mind? I think that's slicing it pretty thin. I mean, administrative law is based on administrative procedure, so kind of like everything is procedural. So I'm not quite sure this procedural substantive distinction is going to work when it comes to the judicial review bar. Interestingly, they also have an equal protection claim that the decision to end the status was based upon racial animus or against Haitians or Syrians or what have you. And if you recall, during the first Trump administration, there was a similar case concerning ban on Muslims, immigrants from Muslim majority countries. And the Supreme Court there basically said that's not reviewable, the president's determination.
Was that Trump v. Hawaii?
Correct. And I think that's principally what the Solicitor General is arguing here, that sure, maybe theoretically you can bring a constitutional claim even though you have this statutory bar, but realistically there's no claim here because of the Trump v. Hawaii case. So interesting issues. Again, some crossover with PLF work, particularly on this judicial review issue. It's funny, there are provisions in environmental law that seem to be similarly draconian. Under the Clean Air Act, for example, certain things that EPA does in terms of rulemaking after 60 or 90 days, if nobody challenges it, the statute on its face seems to say, and this shall not be challenged in a court of law ever again. And there have been thoughts about, well, what if there's a constitutional problem? What if that EPA regulation is being used as the basis of like some sort of criminal enforcement action?
Yeah.
Would review even be precluded there? So I think that on this equal protection part of these cases, there might be more of a PLF aspect to it than one might otherwise think, given the.
What I found interesting, and this is just more a Supreme Court watcher perspective, is there's been a lot of discussion from some of the justices this term about deciding things in the emergency docket. And I think there were like cross motions in the emergency docket on this case. And ultimately the Supreme Court said, we're going to deny those as moot or something like that, and just convert it into a petition for cert so we can decide it on the merits actually here at this term, which I believe is, what Justice Kagan maybe at one time this term actually asked for. So I wonder if there isn't at least a little bit of a acknowledgement by doing that in this case that, resolving the issue once and for all is maybe the better course in some of these cases. Oliver, you still dumbstruck?
Yeah, no, the only thing that this discussion called for me, wasn't one of the immigration cases from Trump's first term, or didn't the court in one of those cases say that the courts could look behind some of the stated reasons by the administration? Normally you have to take what the administration says at face value, and you can't go into the pretext, but wasn't there an opinion that said something about that?
It was I believe it was the census case, the Department of Commerce case, where the court, I think, concluded that that the stated reasons for including the questions were pretextual, and that the courts could adjudicate that kind of a pretext claim in an Administrative Procedure Act challenge. But as I recall, the court seemed to say it was pretty it was unique to that particular case. It's hard to draw infer too much from that.
And relatedly, I think I recall from Trump v. Hawaii that the court put a lot of emphasis on the president having sort of plenary powers in immigration of foreign nationals issues, and so it gave a lot of deference to the president in that case.
Yeah.
Well, thanks, Damien, for noting those new cases that we'll be watching for. There were two opinions, one real opinion, one at least statement from Justice Gorsuch on denial. Let's start with the real opinion, and this was a case that we covered here on the show, Olivier versus City of Brandon. This case concerned someone who had been convicted of a statute for like proselytizing in Mississippi, served his time, got out, and basically wanted to keep doing it. And this time he sought injunctive relief prospectively under 1983. And based on a Supreme Court case called Heck versus Humphrey, the lower courts had said you cannot challenge this law prospectively because you had been convicted under it, and to rule on your prospective challenge, we would need to de facto rule on your conviction. And that's,
Did this involve a habeas petition, or am I thinking of a different case?
the habeas issue comes up because that's what the court was concerned with in Heck. So Heck, I think, involved, I'm not going to get this exactly right, but I think it involved a prisoner who wanted to challenge the law upon which that prisoner was convicted. And the court said, well, and his argument was, well, I'm just doing this prospectively. And the court said, as a prisoner, that is what the habeas, if you're going to collaterally attack, or you're going to attack the statute, the constitutionality of the statute, that's why we have a habeas statute. Now, this is an opinion by Justice Kagan. It was unanimous. The court said that Heck does not apply in this situation because the person is out of prison, and the person just wants to do prospectively. It's bringing a completely prospective challenge. It does not call into question. It's sort of like cabined the prior conviction. Now, on some level, of course, I think the court recognizes that it is going to call into question the constitutionality of that conviction, but it won't have any legal effect as to that past conviction. And so because it's just a heartland prospective 1983 case that we do here all the time at PLF, the court allowed it to go forward. The big precedent in favor of the petitioner who ended up winning this case was Woolley versus Maynard, the live free or die case, where I guess it was Woolley, had successfully challenged under the First Amendment the requirement that he put that on his license plate. He had been convicted under it. I think it's a he, Mr. Woolley, in a prior enforcement action, but was only challenging it prospectively. So you had these two classic precedents. The lower court here, the Fifth Circuit, had extended the Heck precedent, saying you can't collaterally attack these cases. The Supreme Court sided with sort of the Woolley line and said, no, if it's a purely prospective challenge under 1983, that this person can go forward with the case. I remember from the argument, and I haven't had a chance to read the opinion thoroughly, but I remember from the argument there was this issue that there are other individuals that I think were also challenging it, and so it felt like it was somewhat of a mountain out of a molehill, maybe. But I don't think the Supreme Court really addresses that issue.
Yeah, wasn't it also important that he was not seeking damages for his previous conviction?
Exactly, yeah. Now, I think the state's argument, an oral argument, if I can recall some of that, was, well, the moment you tell him that the moment he finds that this law is unconstitutional, don't be surprised if he turns around and files an action for damages for wrongful incarceration. Well, and I guess the Supreme Court's like, well, we'll address that when the time comes. But as far as whether he can prospectively challenge the constitutionality of this proselytizing on the street corner statute, Supreme Court says, yeah, go for it. You can challenge it.
But the court didn't rule on the merits, right? It was just whether he can go forward with the suit.
Yeah, exactly. Yeah. The only other written opinion that I think came down since we have last spoken was a dissental from Justice Gorsuch last week, and this dealt with an individual who had been convicted of a crime and sentenced to 120 months in prison. He served 105 months of that, followed by 15 years of supervised release. He violated his release terms and got sent back for a couple more months, let out, violated his release terms, got sent back for a couple months, until he then hit 120 months. And then he was let out again, and he violated his release terms, and they wanted to put him back in prison. And his argument was, I've already done 120 months in prison. That was the maximum allowed under my sentence. How can I, and he wasn't even saying that they couldn't put him in prison more. He said, if you want to put me in prison more, I am entitled to a jury to determine whether the facts are true over and above the 120 months. The lower court said, no, you're not, and threw him back in prison. Justice Gorsuch writes a pretty short dissental saying this raises some serious Sixth Amendment issues. All he wants is his day in court, his Sixth Amendment right to a jury of his peers and to confront these facts. He's being sentenced to something that more than a jury ever sentenced him to. Isn't he entitled to that? seems like a pretty decent point to me, but didn't command any other justices.
I was going to say, I assume Justice Alito agreed with him?
I didn't see the statement respecting denial from Justice Alito, the counter statement, if you will. But we'll see if that issue reappears in future Supreme Courts, but I don't know how common it is either. But it's an interesting issue, interesting legal one at least, and raising constitutional questions. Oliver, you've been on a couple panels. You've been making the circuits, discussing some of the cases that are upcoming in the next couple weeks of the term. Take us on a journey. What do you want to talk about?
Sure. There are 4 cases next week. I'll discuss 2 of them, but just quickly, the 2 I'm not going to discuss. One is Watson versus Republican National Committee, and the question there is whether federal statutes preempt a state law that allows ballots cast by federal election day to be received and counted by election officials after that day. And then the other case I'm not going to discuss is Nome versus Otro Lado. The question is whether an alien who is stopped on the Mexican side of the U.S.-Mexico border, quote, arrives in the United States within the meaning of the Immigration and Nationality Act, which says that an alien who arrives in the United States may apply for asylum. And so apparently he was stopped before, but he says, I'm at the processing center I arrived in, and I should be allowed to file for asylum. The 2 cases I am going to discuss next week.
Briefly, it's like, let's say that, for example, I don't really have a dog in this race, but if, for example, the rule is that, yes, once you are on the Mexican side of the border and you can avail yourself of asylum there, isn't the response from America then to just stop you a little bit earlier? Does the border keep moving until eventually, like, the border is at Belize or something?
Yeah, right. And I don't know how this works. How do you process anybody?
If America's goal is to prevent people from coming to the country and seeking asylum, are they just not allowed to pursue that goal? Maybe it's an illegitimate goal. I don't know.
Yeah.
Well, I think the issue is, and I know less about this than I knew about the TPS case, but anyway, I think the issue is that you have the processing centers in the foreign country, so that gives people an opportunity to make their claim, but then it doesn't it doesn't burden the United States to say, well, now they're already in the United States, what if we lose track of them, what if they, but if it turns out that even a processing center in the foreign country is still in the United States for purposes of asylum, then the government might say, well, we're not going to have any processing centers, and then
that's the alter. Yeah, that's it.
Yeah, and so it might be kind of a perverse consequence. But anyway, I recall this because I think there was a pretty strong dissental from the Ninth Circuit in Bank, and it was like a very textualist thing that in the United States means not outside the United States.
Yeah.
So I recall, I can't remember who wrote that, but I was a pretty engaging dissental.
Speaking of Ninth Circuit dissentals, what are your thoughts on the Van Dyke dissenting? Anyway, Oliver, I cut you off.
No, that's fine. Another case that's going to be heard next week is Keith Lee versus Buddy Ayers Construction. Thomas Keith Lee was involved in a car accident hit by a driver who worked for the construction company. Keith Lee sued the construction company for damages. And at some point, the company filed a motion for summary judgment and argued that Keith Lee's case should be dismissed on grounds of judicial estoppel because Keith Lee had not updated the bankruptcy court with this lawsuit. And Keith Lee's this was he's in the middle of his 4th bankruptcy proceeding. And so the construction company obviously knows that he is required to update the bankruptcy court with all potential assets and recoveries and things like that. The trial court granted the construction company's motion and the Fifth Circuit affirmed. And the petitioner, Keithley, suggests that there's a circuit split. The respondent, of course, not surprisingly, disagrees. And the question, in part, will be how strict is the test? And in the Fifth Circuit, at least again, according to the petitioner, that if there's any suggestion that a plaintiff failed to update the bankruptcy court about a potential lawsuit, then it must have been intentional. And that's the end of the case. The respondent's, I'm sorry, that's the respondent's argument. The petitioner's argument says that this was an inadvertent mistake, that the practice in the Eastern District of Arkansas, which is where the bankruptcy proceeding is being held, doesn't require updates immediately, that as long as you update the court before the final proceedings are done, then it's okay. It didn't affect anything in the bankruptcy proceeding, and that if this ruling is upheld, it's a windfall for the construction company because it has no benefit or loss from the bankruptcy proceeding, and it's just going to prevent the plaintiff from pursuing a potentially viable claim. That's it.
Is there a Paul Clement for the bankruptcy bar? I feel like every year there's like 2 or 3 bankruptcy.
There are. That's a good point. There are. Like speaking of which, there are also a number of arbitration cases, and this next case is an arbitration case.
Look at that.
Go on. Speaking of, in fact, one of the cases I
Damien, I
remember,
had a brilliant segue, and you interrupted me. But
That
go
was
ahead.
a good segue.
I was just going to say because
Do you know anything about this, or is this going to be your third foray into something?
I
you know
actually
nothing
do.
about?
I actually do because this is one that we talked about a few times. Remember that this was
Damien's declared for bankruptcy 5 times.
no. This is the case. Now the name of it actually is escaping, but if you recall, it's the one about when you can seek a Rule 60 relief, whether it's like indefinite or whether it's only a year. Well, that was a bankruptcy case, and Lisa Blatt represented the bankruptcy trustee as respondent there successfully. So, so bankruptcy cases do attract pretty high level talent in the Supreme Court.
Maybe Ms. Blatt is the Paul Clement of bankruptcy cases.
Awesome.
There you go. Okay, back to the arbitration case. This case is brought by a driver. Actually, I don't know who brought it, but the question is whether the petitioner, the plaintiff, is exempt from the Arbitration Act, which, and according to Section 1 of the Federal Arbitration Act, it does not apply to contracts of employment. Any class of workers engaged in foreign or interstate commerce. So in this case, Mr. Brock picks up Wonder Bread and other things in Colorado. He's an independent purchaser, buys them in Colorado and delivers them in Colorado. And so the question is whether he is engaged in interstate commerce. There's no question that the bread or whatever the products are that he is delivering are in interstate commerce.
Right.
The question is whether he himself is engaged. And one distinction that the parties have made is that this is different. This is the company that wants to enforce the arbitration agreement. It argues that Mr. Brock is engaged in interstate commerce, and it says he compares differently from, say, a food delivery driver. Because at that point, the interstate commerce, once it gets from out of state into the restaurant or the grocery store or whatever, the interstate commerce part is done. The food delivery driver is just picking it up for a purely intrastate transaction. So it'll be interesting to see what happens, and I didn't discuss. I was on as Joshua mentioned, I was on a panel on Wednesday, and the person who discussed the case said there's not a huge overlap on these questions and the general interstate commerce jurisprudence. And I asked him if Wicker v. Philbin was going to be on the chopping block after this case, and he said no. It's safe for now.
Well, you anticipated my very question.
Yeah.
I will say when I first started working at PLF, Arbitration Act cases were a big part of our practice, especially in amicus practice. We filed in probably every FAA case that got to the Supreme Court and many in the courts of appeals, and I was conscripted to write or at least help draft some of those amicus briefs. And I have retained none of that knowledge, if I ever had any of that knowledge.
Why did we do so much work in that area?
It was part of like a tort reform project where I think our position was, we used to do a lot more amicus work than we do now.
Yeah.
Was
Well,
that,
it's kind of like liberty of contract, right? I
Yeah,
mean,
it's
it's not just
contract,
grind for
but-
arbitration. Now all of a
Labor
sudden,
and-
states are saying, "Oh, well, you don't have to arbitrate." I have a question though, Mr. Dunford.
Joshua, your comments can wait. Damien, go ahead.
So does the FAA? It doesn't apply if you are employed in interstate commerce.
It does not apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce.
Doesn't that seem kind of perverse that the
Yeah.
feds are exempting from regulation really that which really they should only be able to regulate?
Well, there's another arbitration case coming up later in the term, and in that case, the question is the jurisdiction of district courts. And according to the FAA, federal courts can hear those cases, but there has to be a separate basis for jurisdiction. The FAA itself does not provide jurisdiction. So yeah, it's exempting interstate contracts or contracts for interstate workers, and then it doesn't necessarily hear the case. So it's issued this law, and it apparently it allows state courts and encourages state courts to hear these claims.
Damien's point reminds me, wasn't there a case just heard like a couple weeks ago that dealt with a driver from LA that if he drove to like Reno, he would not be subjected because it would be interstate, but if he drove intrastate, that somehow the statute covered him for tortious acts. I don't remember exactly what the facts are. Is that ringing any bells for anybody?
But
No,
you're saying, Oliver, that the statutory scope of interstate commerce is narrower than what Congress can regulate currently under Commerce.
Yeah, I don't know. The question I asked of the panelist was how much overlap is there, and he just said it's not a one-to-one comparison. So I don't, as you would say, I don't know anything about this field, but I thought that was interesting that there is some, even though the words are the same, obviously, and it's the basis for the Congress's action, that there is some distinction.
Yeah.
Montgomery versus Caribbean Transport 2. It was just argued on March 6th. We talked about it. It was probably Oliver. That's why he doesn't remember.
That's why I can't remember.
It was a negligent hiring claim where it somehow only covered them if they were intrastate. It was really interesting. Any more cases you wanted to know? Those are the four coming up.
That's it.
Anything else from you, Damien, or are you guys ready for your big quiz of the day?
Let's take the quiz.
Let's go.
All right, we're going to go back and forth. We'll start with Mr. Dunford. There are 1, 2, 3, 4, 5, 6, 7, 8, 9, 17 Chief Justices of the United States Supreme Court. Let's see you get them all. You can start.
J.
John Jay, number 1. Damien.
Rutledge.
Is your name Damien? We're going back and forth, tough guy.
I thought you said. I thought I was just going to go. All right.
All right, you got Jay. I'll give you Rutledge. Damien, you got a name 2 now.
You can go 2.
How about White?
Edward Douglas White. Very good.
What?
And Tawny.
All right.
Marshall.
Now just do one. Marshall. All right. John Marshall. He's a big one.
Hughes.
Charles Evan Hughes. Very nice.
Douglas.
Yes. Where is he? Wait. Did we already do Douglas?
Maybe our production assistant could get you a better one.
All right. Damien.
Taft.
William Howard Taft.
Berger.
Warren Burger.
Stone.
Harlan Fiske Stone. Damien going with the deep cuts.
Yeah.
You guys might get them all.
Rehnquist.
Rehnquist.
Warren.
Warren.
Roberts.
Roberts.
Kavanaugh.
Is that what we get?
I think I'm tapped out. Oh no, Chase. Did we say
Chase. There you go, Chase. The Ohioan that we learned last time.
I think we're missing a really early one.
You're missing. Yeah, this is like one of the super early
Wilson?
ones.
Was Wilson a Chief Justice?
No,
No.
you only missing 4. You guys got 13 and 17. Pretty good.
Wow.
I'll say one of them I've never heard of. One of them's very early. One of them's from the 50s that you should get.
From the 50s.
Yeah, 46 to 53.
That wasn't Stone?
No.
Jackson wasn't Chief Justice.
Starts with a V.
Vincent.
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 Yeah.
Vincent, yeah.
All right. I'm going to call it there. You guys missed Oliver Ellsworth.
Oh, yeah.
Ellsworth. Yeah. Okay.
Connecticut.
Morrison Waite.
I vaguely.
74 to 88. I can't even think of it.
He was on there for the Slaughterhouse case.
Slaughterhouse,
So
yeah.
That's why, yeah.
It's a long time.
And then Melville Fuller.
What was he?
He was chief
88 to 1910. So that was a
Yeah,
good.
he was chief for Lochner.
Yes, 22 years
then-
for Lochner.
And then, was it Taft after that then?
No, there's one in between Taft. I deleted them all as you said them, but I can go
Stone?
back.
I think it was Hughes. Wasn't it Hughes?
Yeah, it went. It went Fuller, White, Taft,
Taft.
Fuller, White, Taft, Hughes.
Hughes. Okay. Yeah.
That was close.
Yeah. All right, smarty pants. You guys did better than I would have done. So
Well, there were
congratulations.
2 of us.
All right, well, that will wrap it for the PLF Supreme Court Show. Thank you, gentlemen, for joining me. We'll be back next week with some arguments again, and look forward to recapping them for everybody. Thank you for joining us.
See
you
ya.
next week.